In this lesson, what I want to do is spend some time talking about a different type of license which may exist in various different forms within land law. This is the idea of a license which may be coupled with an interest. We'll explore what this means in this lesson and then the various contexts in which we can actually establish this principle. Now, as a basic introduction, the previous lesson looked at the concept of a bear license. If you haven't seen that lesson, go back and watch it first. This gives us the most basic form of license that is able to be granted over a property, and it includes what could be expressly stated, so the expressed permission for an individual to enter onto your property, or it could be impliedly permitted, i.e., the implication of the nature of the job, or maybe the nature of the relationship between you and the licensee and the licensor, that could therefore imply the existence of a bare license. I use the example of a postman or postwoman who goes through and has license impliedly to enter onto your front garden in order to deliver the mail. Obviously, you don't give expressed permission at every single time a postman or a postwoman comes onto your property. Sometimes you don't even know they're there. It is only until the dog starts barking that you know that they're there. So that's what the previous lesson examined. This lesson is going to examine the existence of licenses which may arise out of the existence of an interest, and these are known as licenses coupled with an interest. So, what do we mean, and what is the basic fundamental rationale between the idea behind the idea of a license coupled with an interest? Well, these kinds of licenses will arise where there is some proprietary interest. Remember, licenses are not proprietary rights; they are only personal rights. They are not rights in rem, only rights in personam. So, a license coupled with an interest, however, will arise where there is some proprietary right, some right in rem, that is granted to an individual. And in order for them to be able to use and or enjoy that proprietary interest, they must also have granted to them some kind of license. So the point here is that the license arises out of some other interest which is likely to be proprietary in nature. In these circumstances, therefore, what will happen is that the license will represent a subsidiary interest to the proprietary right. However, so long as that proprietary right exists, the license that is necessary to enjoy that right is irrevocable, because in essentially in revoking a license which is coupled with an interest, you are infringing on the use and enjoyment of a proprietary right, which is of course something that you cannot do as somebody who is granting a license. Now, there are two cases that I would like to illustrate this point in this lesson after this particular slide. And what really should be noted is that there has been something of a development in the law in this area, because in the traditional context, in the traditional way in which this was viewed, the interest which gives rise to the requirement of a license needn't necessarily be proprietary. However, we see something of a development in this area of the law, and we will get to that in a second. So fundamentally, therefore, just as a basic recap before we talk about the development of this area, a license may exist as being a necessary requirement for the fulfillment of the use and enjoyment of a proprietary interest. That is what we are discussing here. And I will point you to the first case from 1915. This is the case of Hurt and Picture Theatres Limited. This was a case in which the claimant had gone to a theatre, but they were removed from the theatre on the mistaken belief that they had not, in fact, brought a ticket. A ticket sounds quite old-fashioned in terms of the language these days, but this is essentially how theatres used to work. I guess you could say that you have theatre tickets today, but it feels rare to me that people refer to this as a cinema ticket. I don't know why. Maybe because it's all digital these days. It's all done on your phone. Anyway, The claimant argued that, one, they were entitled to be there since they had in fact brought a ticket, and this was actually a mistaken belief that they hadn't brought a ticket. And two, the removal of that individual, which was indeed forcible. It was a forcible removal because he protested the fact that he had in fact brought a ticket. The fact that the removal, which was forcible, happened amounted to a trespass to the person. Now, the theatre, in response, argued that while they may have been in breach of their contract by removing him, because in reality he did in fact have a ticket, and so they were breaching their contractual side of the bargain in the purchase of the ticket by not providing the service of a theatre and a theatre experience in a movie. They argued that, yes, they may have breached their contract by removing him, but once this contract had been in breach, the license to be on the property had been terminated, and they were in their rights to do whatever they so chose and so wanted to do in relation to that individual. They no longer had a license to be on that property as a result of the fact that they themselves had breached their contract by removing him. Now, the courts decided that where there is an interest which is coupled with a license, in this case we have the existence of a contractual interest. The purchase of a ticket at a theatre is contractual, and it is coupled with a license. You have license to be on the property, and you have license to sit in the cinema and watch the movie, so long as you have a ticket, which is of course the contractual interest, which is then coupled with the license. So where there is a license coupled with an interest, that license is irrevocable so long as the interest is still valid. And so the debate here was whether or not the interest was still valid. But the point for us is that the courts held that so long as you still have a valid interest, then you will still have a valid license. And so one cannot revoke the license so long as that valid interest still exists. Couple this then with the 1971 case of Hounslow LBC versus Twickenham Garden Development Limited. This was a case which involved the claimants, who were Hounslow LBC, and they were seeking to evict their building contractors. They applied to the courts for an injunction to be granted against the defendant, Twickenham Garden Development Limited. These were the building contractors. To which the defendant argued in response that since the license to reside on the property was coupled with this idea of a contractual obligation, it therefore could not be revoked. The High Court, however, came to the conclusion that the injunction could not be granted, since there had not been proper notice on the part of the claimants that the contract had been terminated. As such, as a result of this, the injunction could not be granted since there was an implied obligation that the license will not be revoked. It will be irrevocable so long as the contractual obligations remained in place.